Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about something very important, something that many people are scared of when they receive it and they do not know what to do with it. It's a notice to appear. Notice to appear is an invitation for one to come to court, immigration court, when he or she is placed in removal proceedings. You may receive it usually after you file for something that was denied. Let's say petition by a relative or by an employer was denied. You may receive it if you were not granted asylum in the asylum interview. If you overstayed your visa, for example, in the United States, or if there were any kind of criminal charges against you and the government learned that you were here without any status. So what's going on with that? Number one, people always ask me, I'm so scared to go there. Will I be deported? Will I be deported on the first day if I go to court? The answer is no, you will not be deported on the court date. But if you don't show up, for sure, you will be ordered removed without you being present there. So the government has to give you notice of the time and date and place where your proceedings are going to take place. Recently, I've noticed that the government stopped doing that effectively. They sent you a notice with date and time. When you come to court, it's not your date and time. There is no hearing for you. They say that you were not in the system yet. And then they forget to send you a notice of the new date and time, and they just place the date and time in the immigration 1-800 system. And if you don't check the system for whatever reason, you will miss the date when you need to come to court, and you will be found removed without you being there. So first of all, the notice gives you the date and time and place of your hearing, and by law, it must be provided to you. It must be provided to you. If there is no notice, if you miss the hearing, that removal order that will be issued against you, if you did not know about the date and time, is not valid. The proceedings should be reopened, and you should have an opportunity to defend yourself in court. On the first court date, you will not be found removed if you show up, because that's not the date for that. The first court date is a master hearing. It's only to determine how you're going to be answering the allegations in the notice to appear, what defenses you're going to have against the removal in the United States, to determine various deadlines, and at times to figure out if you will qualify for some forms of relief. For example, there can be some question about whether your conviction is a crime of moral turpitude, and you and the government need some time to determine that. Or there can be a question of whether your visa case is strong enough for the court to give you an adjournment. Because nowadays what happened is that the judges were ordered not to give you time to get relief with USCIS. Basically, now the Board of Immigration Appeals ruled that if you have an application pending that should be decided not by the immigration judge, but by USCIS, immigration judge does not have to adjourn your case to give you that time. But I think it's very, very, very unfair. But that's the reality of what we have to go through right now. So the first date in court is not going to determine much. Except for, of course, you need to know what is it that you're going to be asking the court in terms of relief. If you're going to be asking for voluntary departure, basically that you're going to be leaving the United States without the order of deportation or not. And that's what this court is for. You cannot miss it, because if you miss it, there will be an order of deportation or removal against you for sure. You have to show up, but you will not be ordered deported. Will you be detained in court on the first day? That's the other question that people ask me. Usually not. Usually, I've never heard when somebody would be detained if they come up, if they came to court for their first master hearing. I cannot say it cannot happen, because I guess anything can happen nowadays, but honestly never ever heard that somebody would be detained, because also if they planned on detaining you, you would be detained already. Okay, if you received your notice by mail, it means that's how the government chose to handle your situation rather than detaining you. In theory, anybody who does not have a status in the United States can be detained. Then, of course, many will qualify for bond, but it doesn't mean that everyone will be detained. Those are separate issues, and it's impossible to detain everybody, right? So that's why we have bond provisions as well, that the person can qualify for immigration bond in most situations, unless, of course, certain exceptions apply, like a person has an aggravated felony conviction in their record, or in some other situations when they're arriving early and things like that. So the first day in court is important. No, you will not be deported on that day. You do need to know what your plan is. If you don't have a lawyer, shall you still come in? Absolutely. It doesn't matter if you have a lawyer or not. The government in the United States is not obligated to provide you with an attorney for immigration proceedings. But you, as a person, you must show up. If you don't have a lawyer, you should inform court about that, and that you are planning on having a lawyer if you are. And in absolute majority of cases that I know of, the judge will give you time to find that attorney. Sometimes they're going to give you time twice and 3 times to make sure that your rights are going to be preserved. Because once you're going to be responding to that motion, notice to appear, answering allegations, your answers will be locked. In most of the situations, you will not be able to change them. So it's very important to know what you're doing and not to waive certain rights, forms of reliefs that you would like to apply for later. So that's important. So that's what's going on the first day in court. In New York, at least, what happens is those appearances usually are scheduled in the morning, 8:30, 8 o'clock, from 8 to 10 o'clock in the morning. You come in and there are many people waiting in the same room. That particular hearing is an open hearing, meaning that there will be other people in the room waiting for their turn. So there will be a judge, a prosecutor, judge's clerk, interpreter in certain situations, usually not on a master hearing. For people who have lawyers, usually the judge will ask an attorney if the client waives the right to have this particular hearing interpreted. Why? Because the client does not need to testify during the master hearing. They will not be asking you questions about the substance, let's say, of your asylum claim. This is not the hearing for that. This is the hearing just to determine the deadlines, to accept the forms of and applications and forms of relief that you're going to be filing for. This is what that day is for. So no, you're not going to be arrested. No, you cannot miss it. Yes, you should be showing up, preferably with an attorney. So the whole hearing lasts for about 10-15 minutes the most. Okay, it's very quick. You just basically check in with the court. But sometimes you have to wait for your turn for some time for a very long time, depending on the judge and the day and what's going on that day. And I have actually other videos about how to prepare for the court, and on my YouTube channel, and I have articles about that on our website, www.shautsova.com. Thank you.